Hey, welcome to the Consumer Debt and General Civil meeting of the California Paraprofessional Program Working Group. I can begin by taking roll. Reynoldson,
Here.
Fleischman,
Here.
Hamilton, I haven't seen. Hartston,
Here.
Robinson, no, Shining,
Here.
Judge Yu is not with us yet, and Hamilton now.
Present.
Great.
But I'm going to go on stealth mode for a second. I've got to give some instructions to a staff member.
Okay. So we have a quorum. When to begin?
Carolyn, do you want to see if there's any public comment?
Do we have any public comment?
I see we have 8 attendees. If anyone wants to make comment, please raise your hand in the Zoom meeting. I don't see any raised hands.
All right. So in preparation for this meeting and kind of in response to what was raised at the end of our last meeting, I did send out several draft resolutions for the group to consider. I can put them on the screen. I didn't do a PowerPoint for today, but I don't need to put them up on the screen if folks don't think that would be useful. But I was thinking that we would basically go through not necessarily each resolution, but see if there are members of the subcommittee that want to ask any questions about the drafts and or to propose that the subcommittee adopt a specific resolution. So that's what I was thinking. I don't know, Carolyn, if you had another thought as to how you wanted to proceed today.
No, and I want to thank you for getting those out because I know I have been quite vocal about asking for them. And then, of course, I did not have time to look at them myself. And I glanced at them and I want to apologize and thank you very much. So they are complicated. So maybe with PowerPoint would not necessarily be helpful, but I see Steve has his hand up.
Yeah, I'd really like to finish today. And so my suggestion is we start with at least what I think is the low-hanging fruit, which is basically everything other than consumer debt. On creditor harassment, we talked about this at the last meeting and we didn't take any straw polls or anything, but I conveyed my view that I thought it was too complicated and the problems with the federal preemption complicated. Julia said she agreed, but wanted to include the pre-litigation letters, which I agreed with and thought was a good idea. I would never hold her to it, but I thought I saw Erica nodding her head in agreement. In the past, Carolyn and Steve have, I think, expressed the views that they don't really think creditor harassment belongs in the program. So, you know, my view is I'd like us to adopt my version of the resolution, but we can eliminate the 3rd bullet point because it's redundant of the first line of the resolution. In other words, it's the first line is resolve, blah, blah, individual debtors. I had individual debtors as a separate bullet point. We don't need the 3rd bullet point under included.
Okay. So are you making a motion?
Sure, I'll make a motion that we adopt my version on creditor harassment. The one thing I added, if I didn't say, is I have no problem, including in the program, negotiating settlements, payment plans, that type of stuff, pre-litigation, if that's part of it. But as I put, all Superior Court litigation in this topic should be out of the program. So I make a motion to approve that. Julia, do you want to second it? I attempted to encapsulate what I thought you and I had agreement on.
I think that is what we agreed on. Does the settlement include then the prove-up letters? Do we need to state that in your second version or?
Well, I've got the prove-up letters in the first bullet point.
I see that now. Yeah, we just need to move the and then.
Yeah, and put a period after the plans.
I second the motion for version number 2 as edited.
Put the
I
and
have-
after letters, Linda.
Amos, did you make a,
I
Did
have
you-
a question. So I think I may have missed a meeting or something, so I'm not fully up to speed, but I'm trying to understand if paraprofessionals are allowed to negotiate settlements, they would also be allowed to do things like draft settlement agreements and things like that, right? So this is not intended to be an exhaustive list. This is that it's really excluding in-court representation. Is that right? And if that's the case, is there some reason why we're excluding consulting related to Superior Court litigation?
Sure. In the back of my mind, Amos, one thing that bothers me about this program is the issue of ghostwriting. And so that bullet point is my attempt to address that issue.
So wouldn't pro per litigants in this area be better off with the ability to consult with and have ghostwrited materials?
You know, on the one hand, yes. On the other hand, you could say the same thing about a disbarred attorney. So I don't know the answer. You know, I mean, you know, the bigger issue is, are we going to list things that are included and excluded, or is everything excluded that's not included? If you're saying you want to exclude the excluded, pun intended, I could probably live with that as long as there's an understanding if it's not included, it's excluded. But that was my intent.
I think in some other subcommittees, we are, I guess, taking slightly different approaches to that. So I think, you know, assuming it's included unless it's specifically excluded. So what I think is being attempted here is specifically excluding in-court representation, which I think is fine. But I'm just not sure about the consulting, so out-of-court consulting about that. And for the including part, I just want to make sure this is not intended as a exclusive list, because I do think like drafting settlements agreements will be necessary. And releases.
Sure. Pre-lawsuit settlements, fine. My gut is, Amos, those would be drafted by the creditor's side, but would need to be reviewed. But yeah, I'm fine with that. So do you want to delete the words including consulting? Is that your amendment?
Yeah, if that could be a friendly amendment, that would be great.
I can live with that. Julia, can you live with it?
Yes,
With
because
that,
I think the confusion is just what Amos says, and I think we're ultimately, since we have included the two intended types of actions they can take, it makes it easier to understand, because consulting is really broad and a vague term, I think.
sure.
Is there any kind of catch-all bullet that we could, because we are having a list of included activities, is there a third bullet we could add, like other pre-litigation activity as needed or something? Just to kind of get it. I've been struggling with this, which is why I gave you all multiple options for these resolutions.
Yeah.
So I don't have a perfect suggestion, but I wonder if we need a catch-all bullet.
So you're suggesting something like pre-litigation consulting?
Like included, we would add a bullet, other pre-litigation activity as needed. I don't know, just because we were very specific about cease and desist, prove up, negotiation.
Yeah,
of
could
settlement.
Leah, could you identify some activity pre-litigation that wouldn't fall under the umbrella of settlement negotiations? I'm just having a hard time thinking of what you're thinking.
I was just following up on Amos's point, but if
Okay.
if it's really just about settlements And so negotiation of settlements includes drafting settlement agreements, and we don't need to be explicit about it. Then maybe maybe this does capture everything.
Yeah, I think we decided after our last guest speaker that when he talked about the kinds of things that the last guest speakers have made it really clear that, you know, things get complicated really fast, and we have to, I think, show that we're trying to stop at that point.
Unless anyone else wants to be heard further on this, I'd call the vote. Let's vote on this.
I just, as the chair, I don't think I'm allowed to vote unless there's a tie, and we're not doing a straw poll. So I would just, you know, before we vote on this and the others, I have been listening as best I can to what's going on in regulation with regard to the ethics rules. And it gives me a lot of pause. And what we did also with regard to the in-court, out-of-court, full court vote on the 26th. And it's really changed my views on a lot of things as far as how we've gone through this, to have to go back and then now define what pre-litigation is and what litigation is. I'm really going to have a problem supporting really a lot of things, including a lot of these areas today. So I just kind of want to make that clear. If that influences anybody's vote, or if anybody wants to ask me any questions as to why I've come to that position. But I know Amos and Greg and Farish have been doing a ton of work, and I really appreciate that in the regulation section, but we don't have that finalized yet. So knowing what is going to happen with regard to that interface that Julie mentioned, when it gets really complicated really fast, you know, we're jumping into a lot of areas, and we're moving in terms that, you know, when I started this in April and June, and we decided to go through all the areas of law that could possibly be, and then we spent, you know, 3 months with 50 meetings going through what that would winnow down to. I don't think we've done justice to what creditor harassment even means. So that's kind of
Carolyn,
I'm willing to hear out other people on that.
Carolyn, if I could respond, I feel your pain. I really do. But we are where we are, and I'd really like to finish all of these 4 areas today. So I would like to call the vote on adopting version 2.
Hearing us, I don't hear anything else. Anybody else?
Reynoldsson,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston.
Yes.
I think Robinson is not here, and Judge Yu is not here, and Carolyn is not voting. So the motion carries.
And just, I've got my Robert's Rules of Order buried somewhere in the office from another group. I think on a subcommittee, Carolyn, I think you're entitled to a vote. I think that's strictly if you're the president of the organization or the CEO and there's a motion, you're not allowed to make a motion, and you're only allowed to vote in the case of a tie. I don't think it applies at the subcommittee level.
Okay, so then Carolyn, would you like to vote on this?
Yeah, I'll vote no.
Okay, recorded that. Thank you.
Your voice will not be squelched.
Thanks, Stephen. Steve?
Yeah, Carolyn, with your permission, could I move on to utility shutoff?
Yes, let's do that.
Okay, I read Leia's email. I don't think Leia proposed a resolution. If she did, I missed it. But what moved me is that most utility shutoffs are under $500. And therefore, I'm not trying to put words in your mouth, Leia, but I got the impression you were skeptical a paraprofessional could help, given the amount of money the paraprofessional would have to charge relative to the amount in dispute. And if I'm reading that correctly, I would move to exclude utility cutoff from the program. But I want to hear from Leia, because I want to make sure I'm interpreting her email correctly.
Right, that was my takeaway from the conversation with the woman at Turn. She did raise, as I put in the email, several other areas that might be useful, but my takeaway was utility shutoffs is likely not one of them.
Would anyone like to second my motion?
Well, before we do, well, I don't know if I'm allowed to interrupt now or wait, but
Absolutely, you can.
utility shutoff for me has two different meanings. One is if it's the utility that's shutting it off for non-payment, for example, or in the context of a landlord-tenant dispute, when it's harassment or attempt to, self-evict or things like that. And for the landlord-tenant type disputes, I think that might fit into what the housing group has tentatively authorized. In other words, all out of court landlord tenant disputes, negotiation and dealing with that. So I'd hate to see us explicitly excluded if it should be included with the housing in the landlord tenant context.
May I amend my motion to say exclude utility shut off except in the landlord tenant context as recommended by the housing subcommittee?
Can I suggest just slightly different, because the way it was written in the Justice Gap report was utility shut off due to non-payment. So maybe that would be the easier way to do that.
I think so.
Fine by me if it's okay with Amos.
Yeah, but I think it matters if it's non-payment of rent versus non-payment directly to the utility company. So I don't mean to complicate it. I just know utility shutoffs come into play in the housing context.
Well, let's just say, can you put up a draft resolution, Linda? I'm
Yes.
sorry. You could type it on this document just for ease right now.
Sorry.
Utility shutoffs for non-payment of utility services. Excluded. And I think if we want it like resolved, comma, that utility shut off for non-payment of utility services will be excluded from the paraprofessional program. So I think, Steve, that was your motion. Do we have a second?
Second,
Any discussion? Okay, Linda?
Reynoldston,
yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
No,
Shining.
Yes.
The motion carries.
Amos, just can I ask, were you a no vote because you don't like the way this was worded?
yeah, I think it's going to cause a problem for paraprofessionals in the landlord tenant space.
Amos, it's my motion. I'm fully open to any amendment you want to make to address that concern. I will vote for reconsideration. I will, you tell me what language you want to address that issue and I'm down with it.
Yeah, I think this might work, except in landlord tenant. Because I think the problem is it's going to create confusion that a paraprofessional is excluded from dealing with utility shutoffs in the landlord tenant.
Can I suggest that we defer that issue then to the other subcommittee?
Yeah, and my understanding of where we are in the house, so I'm on the housing subcommittee. My understanding of where we are is we've generally included all types of pre-litigation landlord-tenant disputes. And this certainly could be, included in that. So that's still at the proposal stage, but yeah, so I certainly like it better with that expressed in there.
I move to amend the proposal per Amos's suggestion as on the screen. Amos, would you like to second that?
I second that, sure.
Brady, will you give us a pass and let us proceed without moving for reconsideration?
He's muted.
Yeah.
Okay.
I would just say there's a lot of double negatives in there, except, resolved, except, excluded. I don't know that it clarifies anything, really. Do you need, you're in housing, Amos, do you really believe that I don't know, it perplexes me how we as a subcommittee can now go back and revise a default on something that you think should be excluded.
So I think you might be misunderstanding. I think the housing group would consider a landlord-tenant dispute that includes a shut-off of utilities to be included in what's being proposed. And my concern was we were doing something here that might interfere with a paraprofessional assisting with utility shutoffs in the landlord-tenant case. So I think this does solve that problem.
Brady, are you able to opine on the proper procedure? It seems like we have a substitute resolution.
I mean, it's just sort of like we did with the last one. We can just restate the new
All right.
resolution. We don't follow strictly Robert's rules. It's a guide. So as long as you know what we do results in clarity.
I'll pull it out though.
Fine to proceed.
I will pull it out.
We know.
I've got a version in this deck.
In that case, can I call my vote?
Yes, Linda.
Okay, Reynoldson,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Shining,
I'm going to vote no on just the way it's worded. I think it's going to cause confusion in the future, but I'm outvoted. So there you go.
okay, motion carries.
All right, Steve, you're on a roll. Where should we go next?
In my opinion, wage garnishment is the next low-hanging fruit.
Okay.
We heard extensively from a woman, and I apologize, I forget her name and I forget the legal organization.
Elizabeth Gonzalez Public Law Center, which is the woman that helped me develop the attachment that I
Yes.
provided to all of you.
In my mind, this is there are pros and there are cons. I feel very confident paraprofessionals could be trained to fill out the forms and file them. Where I have concern is actually the actual litigation of those objections in Superior Court. If I had my way, I would exclude this from the program for now in the pilot, and it would be on the list of things to consider in the future. However, I don't feel that strongly about it, and I'm fine just putting it to a vote, but that's how I feel.
Okay.
In other words, my vote would be to exclude wage garnishment from the program for now.
Others?
Julia, what do you think?
I don't know.
Okay,
What are you on the fence about, Julia?
Well, I mean, I just don't remember that we've had such a substantive talk about wage garnishment in terms of feeling that I had a strong feeling. I don't know. I'm willing to basically do what the group wants to do in that regard. I'm not, I don't know. I don't know where I'm at.
I can't find my
Amos,
hand
how
raised.
about you? Or Steve?
So I don't know that we need to specifically, we're dealing with wage garnishment and enforcement actions as long as we're making clear that is not applicable in family law cases, or because in family law, there are going to be wage garnishments that are going to be prepared. They're very easy forms to prepare that you have to use a federal form at this point in time. So I want to make sure we're not saying all wage garnishments, but just non-family law wage garnishments. And then the second issue, I think why in the past I had been concerned is because of the devastating effects that this could have, that I wanted someone who had a bar license that could be taken away if they misused a garnishment procedure. Maybe the impact would be the same on a paraprofessional, but I think it was the potential risk or harm to the public that had me not include this in the initial round of paraprofessional services.
So Steve, I think we're only talking about representing individuals who have had their wages garnished. So not representing creditors doing the garnishing, if you will. Does that alleviate your concern?
I think there still needs to be a carve out for family law, because you would file your claim of exemption in the family court if you got served with the wage garnishment. I think that's going to be in the scope of services for the family law paraprofessionals.
I
Do you
think
agree, Julia?
So if it's
I'm gonna-
in the scope for the family law paraprofessional, does it make sense to exclude it?
Yeah, I'm gonna raise my own hand. I think this is something, because of what I understand, we haven't decided we're gonna have a whole meeting in May to talk about fee limitations. Again, the people who are having their wages garnished may not necessarily be the people who can afford someone on an hourly basis. And I don't know until we land on that, maybe, because this is like utility shutoffs, this may be something that is for someone who's a very low wage earner. It's going to be 25% is a lot of their salary, but is that something a paraprofessional is really going to step in where Betzedek, where some of those groups can when it's appropriate. So my concern is, again, there's a lot going on still with regulation that we don't understand is finalized yet. Leah asked me earlier, does that mean you want to continue this kind of stuff? Like, no, I don't. I think I would, if I would suggest continuing all of this, but I'm not sure that's going to be really, and I think I'm also outnumbered in that sort of thing because there is this really tight schedule that we have. So if we have to decide it now, I would say let's put it out, because there's too many questions in my mind about what's to come.
So then why can't we do the same carve out that we did for utility shutoffs and say, we resolve that wage garnishment will be excluded from the paraprofessional program, except as it pertains to the family law practice subject area.
I second that if Hamilton's on board.
Stephen?
I'm waiting to see the. Yeah, I think it's good. Yes, I think that's right, but I'm waiting to see it typed.
And my problem is that it always makes sense in the committee, but let's think about what someone in the legislature or the courts is going to say when they see this. And I'm not sure the clear statutory interpretation is really going to be where we're going here.
Well,
Steve, you know those standards of evaluation of those the canons better than I do, I'm sure.
Well,
Do we want to say family law proceedings or family law practice area?
let's just keep practice area so that they can do their own, they have the freedom to deal with it. I don't want to limit them any further. That's my vote.
Steve, as soon as you say thumbs up, thumbs down, I'm going to call the vote.
I think I'm fine.
Can we call the vote?
Yes, I don't object.
Brady, you have your
Where
hand
did
up.
who made the motion?
Steve,
Julia and I seconded it.
But just a second, Brady, is this a current hand?
yeah, I just wanted to, and I'm jumping ahead of our presentation in April, but sort of to respond to Carolyn's concerns. I think what I'm hearing is her concern that these recommendations aren't clear enough. But as part of the implementation process, we staff at the State Bar will be drafting proposed rules and proposed statutory changes that reflect these recommendations. So it's not as if this is going to be all the legislature and decision makers have to work with.
Then why are we here? If this is not going to be what the law is, then what is the point of?
the Board of Trustees is gotta get first dibs on it to decide if they want to support it. I mean,
But-
we're just we're the workers.
You're making the policy decisions that then inform the drafting, right? This is like the condition precedent or the foundational decision. For example, is wage garnishment going to be included or excluded? Now we've got a decision, and then you can go figure out how does this get effectuated through implementing rules and statutes. But you're making the initial decision, in my view, the most important one. What's in, what's out.
I think that having done a lot of digging at the libraries, which I love to do, it still counts. Even if it's just a policy decision, everything we say here counts.
I didn't mean to suggest that it wasn't. It was just your comment made it sound as if you were worried that these words are going to be the only words that the legislature has to guide. And that's just not the case.
All right, well, thank you.
I call the vote.
Okay. Reynoldson,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Shining.
No, but because of the clarity, not the substance.
Okay.
All right. Consumer debt or enforcement of judgment.
So on enforcement of judgments, we started with Judge Dan Buckley from LA Superior Court saying there's a need for representation of debtors in judgment debtor exams. And I think originally Erica and I were okay with that. However, family law, which I think is far more important, has excluded depositions. And if I were before the Supreme Court and I had to explain why we're permitting judgment debtor exams and not depositions, I would be hard pressed to explain why. So on the other hand, under the heading of enforcement of judgments, we have a published Court of Appeal opinion that says renewal of judgments is not even the practice of law in the first place. And so a non-lawyer can do that. So what I attempted to do was include what I thought should be included. Could you put up my resolution? Could you scroll down? And I think we should delete the first bullet point about contingency fees because I think we should just leave that up to regulation. But renewal of judgments and traditional post-judgment enforcement proceedings, I'm okay with. Judgment debtor exams, I was okay with, but I don't want to create an inconsistency with family law. So that's where I'm coming from in drafting this resolution.
So when the issue of depositions came up, a lot of my family law recommendations were made, and I was clear at the time, based on the assumption there would not be in-court representation, and that we have not had a family law meeting to address whether we're going to adopt the default position of in-court representation in our recommendation, and we don't know what the vote's going to be on that. So that was the distinction. I'm questioning if they're going to allow in-court representation and advocacy in the courtroom. I imagine that rule on the depositions might change, Stephen.
Okay.
Because I agree with you. Why would you have somebody be able to appear in court and argue a case, but not be able to ask, and theoretically be able to ask questions of the other party, but not let them do it in a deposition in advance?
Okay, based on that representation and based on what Judge Buckley said, if there's consensus to move judgment debtor from the bottom to the top to be included, I could live with that. I don't feel that strongly about it. My anecdotal understanding is judgment debtor exams happen outside the courtroom. They're intended to be informal. If a problem comes up, you go and see the judge and you get sort of instant justice. That's my sense. Can you delete the contingency fee bullet? Thank you.
I'm just gonna put a plug in for my version up above, which is the exclusion version. If you could scroll up, Linda. It had exclusion, judgment, debtor exempt. So really right now are we intending to exclude anything in enforcement of judgments in your modified motion, Steve? Is there something you're intending to exclude?
Not anymore. So yes, Leah, I agree with you. If you, yeah, and then stop with matters, period.
Yeah.
Could we, this is just a drafting issue. In my mind, it's important to use the phrase post-judgment. Maybe that is already included in the concept of enforcing a judgment, but does someone have a suggestion to make me feel better?
Post expiration.
I
of
could
notice
lie,
of appeal.
Julia. That's all it is.
Post.
I'm glad we could help you.
Post-judgment enforcement proceedings.
Post 6-month expiration of the time to appeal judgment proceedings.
So you want that to be the title of the resolution, or you want it contained in the body of the resolution?
I'm fine with the title. Post-judgment enforcement proceedings.
So you don't want what says version 1 enforcement of judgment exclusions only, because that's not what we're doing.
Yeah, I think we should delete the phrase exclusions only.
Yep.
Yeah, and we would delete version 1. Really, the resolution just is what begins with resolved.
Correct.
Yeah, that's the resolution.
So sorry if this is confusing matters, but I think wage garnishment is sometimes enforcement of judgment proceeding.
It is.
Okay, but this is representing individual. Maybe we address that by saying, oh geez.
I think this is when you have a judgment, there is still a right to appeal. And then when that 15-day notice of appeal runs, you can still come back and, correct me if I'm wrong, with a 473B to get that thrown out again.
Yes.
So post-judgment is, again, a very imprecise term.
I agree, Carolyn. And also this should be limited to debtors, individual debtor clients. Again, we don't need to make cheap representation for banks.
Yeah, we can just say debtors. I don't think they have to say clients.
Yeah.
But let me just ask, we're not interested in banks, and I think regulation has preliminarily recommended that there will be no representation of entities, right? Only individual representation, if I recall from the last discussion on that. But what about a dispute between two individuals? So I want to enforce a judgment against my neighbor. We're saying only the creditor could not benefit from hiring the paraprofessional?
I'm concerned about assignment of debts to individuals to circumvent whatever prohibition regulation comes up with. So yeah, in my mind, that although I hear what you're saying, Leah, that doesn't work for me.
I think we also had inconsistency, or at least a possible one before, because I think somewhere on our list was to include enforcement of small claims judgments, because I think we decided or discussed that that would be appropriate, and I'm not sure how that fits in, or if that really is consistent with excluding it for limited jurisdiction cases.
I thought we got rid of small claims on the theory that in California, small claims, there's no attorneys anyway. And so paraprofessionals shouldn't circumvent that.
So I don't think it's circumventing. I think you can't have an attorney to get a small claims judgment, but getting the judgment is just a piece of paper, and somebody might need help enforcing that.
All right, well, being literal, Amos, this resolution is limited to limited jurisdiction. So this doesn't affect small claims.
But Amos is correct. Small claims appeals, and in fact, I mean, not appeals, enforcement of small claims judgments. And it was Greg's question that prompted us to look more broadly, because his question was, what's the rationale for limiting it to small claims?
Well, I would just point out that Utah is limited to small claims. So in
So
this,
is Arizona.
But I
so
think, I think those jurisdictional limits might be different than California.
it would be good to know.
No,
before we
I
make-
looked at Arizona. Arizona is $10,000 and less is what they call limited jurisdiction court. We call that small claims. So the Arizona program is effectively what we in California would call family and small claims.
And the Utah small claims, I think, is a little bit higher than ours, if I recall. It might be 12,000.
Yes, I think that's right, but it's the same concept. It's, this is sort of my criticism's not the right word, but Arizona, I mean, California has taken a unique approach to small claims, which is no attorneys. It's, it's people's court, pun intended. And, that's how we've chosen to do it. I don't know the historical reasons why, but that's how we've done it. The other states, in my mind, instead of going that way, have attorneys, and so they're trying to even the playing field with paraprofessionals. I get that, but that doesn't move me in California. In any event, Amos, are you okay with the resolution as revised?
I mean, I think I would prefer it not to be limited to debtors, just individual clients.
Okay, so Amos, tell me why I'm wrong. My understanding is large creditors assign millions of dollars in loans to law offices of John Doe, and those entities then go out and try to enforce the judgment. Tell me why, instead of law offices of John Doe, they're not going to assign it to John Doe and now insist on lower cost help. I mean, I'm just trying to be practical here.
Yeah, so I think Leah was right that the regulation subcommittee is proposing that organizations not be allowed as clients for paraprofessionals. So you're talking about sort of a possible workaround for organizations to get, assigned to individuals. There might be a solution to that. I mean, in small claims court, there are limits to how many you can bring. So we might be able to do something similar here, like, no individual can bring, hire a paraprofessional for so many times or something like that. But I think the point is, if a paraprofessional is competent to do a limited jurisdiction and small claims court enforcement of judgments, and it is limited to individuals, I think we might not need the additional limitation to debtors only.
I was going to jump in, Amos. We had this exact conversation in regulation. We talked about the rule governing business transactions with clients. And we talked about the potential for, if for example, enforcement of judgments was excluded altogether, or debt collection was excluded altogether from the paraprofessional program, a workaround would be, that's perfectly allowable now for a non-attorney to be assigned debt and then to take on the matter in pro per, as we heard at our last meeting. But if the paraprofessional, if these practice areas are included, it will be more difficult for the paraprofessional to do that workaround because of a prohibition or rules governing business transactions with clients. Do you recall that conversation?
Yeah, but I think that's a little different because I think Stephen's concern is the client will be the assignee of the debt and they will hire a paraprofessional rather than the paraprofessional being the assignee of the debt. So I think the way it technically works is a creditor can assign a debt to anyone. That and enforcement of that debt is not the practice of law. That's what we were dealing with in regulation. But here the question is, can an individual be the assignee of a whole bunch of debts and then hire paraprofessionals to enforce it? Is that right, Stephen?
Well, yes, but on the other, looking at it from the other hand, I'm worried about banks going to their lawyers and saying, hey, I can assign this to an individual and hire a paraprofessional at $75 an hour. Why are you charging me $200 an hour? That's not what we're designing this program to do. And so that's why I've always been concerned that this program should be geared towards representing individuals with legal problems, not big corporations, not landlords. And we've done that in employment, and we did that in, I guess we're doing that now. So, well, potentially we're doing it now in judgment debtor. So, I mean, that's where I'm coming from. And what I would say is, I hear everything you're saying, but where's the evidence that if someone has a debt in limited jurisdiction, they can't hire somebody on a contingency basis to try to enforce it for them?
So can I ask about, what about like in a landlord-tenant case? Like one of the things we're talking about in housing in landlord-tenant is a security deposit. So the tenant, a paraprofessional is allowed to assist the tenant with getting the security deposit back. And so if they go and they get a judgment to get the security deposit back, if are they not allowed to help enforce that judgment?
Well,
That would-
you know, unless you're dealing with very expensive real estate, I would think a security deposit would be under $10,000 and be in small claims court.
Right,
That's my initial reaction.
but what about the enforcement? Well, you have the small claims court judgment, but what about enforcing that judgment to actually get the money back from the landlord?
My understanding is if a landlord wrongfully withholds a security deposit, there is a host of very bad remedies available to the tenant, which include statutory attorney's fees. And there are all sorts of attorneys who do that work on a contingency basis to recover the fees. And so I'm just not sure there's a need there. But if we want to include enforcement of small claim judgments separately, let's do it. But I'd like to, I mean, we've got other stuff to cover. I'd like to deal with what we have on the table.
So
So
I
you're
would like
not-
to, sorry.
Sorry.
Go ahead. Go ahead.
Well, so Steve, you're saying that you don't want it to just say legal professionals may represent individuals in limited jurisdiction post-judgment enforcement proceedings?
Correct, because that would include creditors. That would include an assignment from Bank America.
I just don't, I don't think that's really going to happen, but maybe I don't know the industry, but I don't think they're going to give this to some paraprofessional and some paraprofessionals going to start being like used by these type of entities, but I may be wrong, but I
Bank
just don't see
America
it.
will go to their law firms and say, why am I paying you $200 an hour when I can hire a paraprofessional for $75?
So is there a way, and I know Ira, he's had his hand up multiple times in the attendees, he's got it down now, but then he just sent me an email. So maybe we can let Ira speak in a moment, but is there a way, as I think Amos was alluding to perhaps it's a contingent resolution that says, dependent on the regulation subcommittee coming up with a solution to this problem? Because I think everyone agrees with you, Steve. I don't think anyone wants to see Bank of America, doing a workaround, and ultimately paraprofessionals are representing Bank of America. So I do believe there has to be a way that we can preclude that from a rules perspective. So maybe
Utah has said that paraprofessionals can only work and can only represent natural persons. I don't think that gets around some of what Steve was saying. But that is in the Utah, in addition to small claims, which is $11,000, they say natural persons. Now, I don't know, in California, is a person is a corporation though. So maybe that's, again, it's unconstitutional. But that's why I really think this one has gotten too complicated. I would be against contingent issues because we're just kicking the can down the road, and we're going to have 40-hour-long regulation meetings, or regulation meetings where we can't get to everything, and then we have an insubstantial record.
My default at this point is, if something's too complicated, it should be out of the program for now. And so, if we can't even negotiate, something like this, I would be inclined just to say, let's just exclude it from the program and move on to the next one. I mean, this is why we're getting bogged down on so many things.
Well, are we in agreement that enforcement of judgments of small claims judgments should be allowed, and enforcement of judgments on behalf of debtors in limited jurisdiction post-judgment enforcement proceedings should be allowed, and the only thing we're really debating is whether creditor side in limited jurisdiction should be allowed?
Yes.
So why don't we just state that?
And while we give Linda time to draft that, can we go, Ira, can we let Ira speak? Carolyn, is that okay with you?
Oh, yeah.
All right.
Well, I only wanted to say what I sent an email to a few of, I didn't have everyone's email address, but I sent an email to a few of you a few minutes ago, making 2 points. So somebody could read the email, or I'll read it if you want.
Yeah, can you read it, Ira?
Okay, let me get it here.
How long is it, Ira?
It's
2
short.
sentences.
Okay.
First, I could be wrong, but I think even in limited jurisdiction, a judgment can be something other than for money. So enforcement of the judgment against the defendant who suffered the judgment wouldn't be against a debtor. I was focusing on the word debtor in this resolution. And then I realized while I was writing it, that if someone wins, say a person, a natural human being, as it were, wins a case against a bank and gets a judgment for costs, which includes attorney's fees, well, then the bank is a judgment debtor. So I was focusing on the word debtor. That's all.
So just to be clear, I don't think that would be a problem, because the regulation subcommittee is proposing that only natural persons, not entities, be allowed to be clients.
Okay. Oh, but what about the defending a judge, somebody who suffers a judgment for something, a natural person, a human being who suffers a judgment for something other than money?
Equitable relief cannot be granted in a limited jurisdiction court.
All right, none at all?
What would you be talking about other than enforcement of judgment or equitable relief?
Well, I was saying I wasn't sure, but I thought there was some that some equitable relief can be granted in limited jurisdiction. I'm almost certain I saw that. In general, you're right, but I'm almost certain I saw that some equitable relief can be granted when I was researching this 2, 3, 4 weeks ago.
Well, I'd say that I don't envision in the licensing portion that we've done anything to really require them to master equitable relief. So I think that would be excluded. So why don't we consider saying, I see that Linda got some of it, but I think what is missing is that it should say legal professionals may represent natural persons in enforcement of small claims court judgments and natural persons in limited jurisdiction post judgment. I think we need to eliminate the word individual debtors and just say natural person?
But then you're including creditors.
Well, then put natural person debtors. Sorry,
Fine.
Linda.
Fine.
And put the same for the natural persons above. Put natural person debtors.
I
We
didn't
just,
think
we
were
just have to
limiting-
just say it.
Were we limiting small claims court judgments to debtors also? I didn't think so.
No, I don't think so. The intent was, for example, the security deposit case, the intent is to be able to enforce that judgment once you get it.
I'm
Wouldn't
looking
that
at
be a
CC
person?
I'm sorry?
It's a person, but it's not limited to a debtor.
Right. It could be the plaintiff.
Oh, the creditor. Okay, I agree. Steve, are you okay?
I got to pull it back up. I was looking at the CCP unlimited jurisdiction. IRA limited jurisdiction equitable relief is almost non-existent. It's quieting title to personal property, equitable defenses, and equitable set aside of fraudulent judgments.
Well, equitable
Okay.
defenses is hardly very limited.
Well, I think we should stay away from equitable relief. I'm,
But equitable
Okay,
defenses
natural
are
persons,
prior
enforcement of
to
small
issuing
claim court judgments, natural person debtors, and limited jurisdiction. I'm fine with the resolution as drafted.
so are you making a motion?
I'm making a motion, we adopt version 1 as modified. Is there a second?
I will second it with the elimination of the words exclusions only in the title of version 1.
I agree.
The title is not part of the resolution. It's just for clarification of this document. It's
Okay,
not at all part of the resolution.
so it's going to be the resolution for enforcement of judgment resolution. And so make your motion, Steve, did you?
I move, yes, I move to adopt what's highlighted.
I second it.
I call the vote.
Okay. Reynoldson,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Shining.
No, and again, because I think it's a hydra in terms of its wordsmithing but I see there's not a lot to talk about there.
Yeah, and I'll probably want to make the note for the report that I don't think it should be limited to debtors, but I do approve of this.
All right. The last one then, consumer debt.
Amos, do I understand housing voted the other day, no jury trials, no bench trials?
Correct.
Okay, I would like us to be consistent with housing. I think the spirit of what Erica requested at the last meeting was to allow bench trials in family law. She's not here, and I'm not trying to put words in her mouth, but that's how I interpreted what she was saying. Look, I'm very skeptical that this belongs in the program. I think the Justice Gap study, where 67% of people with problems don't even reach out to an attorney to try to find help, isn't going, having paraprofessionals isn't going to help that. So I'm skeptical. Having said that, Erica and Greg have convinced me the status quo isn't entirely acceptable either, with the large number of defaults that happen in consumer debt. So I'm open-minded to considering it with conditions, and I think we've already voted jury trials off the island. I think we should exclude bench trials. I think it needs to be limited to individual person debtors. And I have concerns about including, significant concerns about including substantive motions like anti-SLAPP motions and motions for summary judgment. So if you scroll down, I made an attempt in my mind to try to hash out what I thought paraprofessionals should be able to do and not be able to do. I deliberately excluded discovery because there had not been any discussion about discovery. Before today, I was going to say, you know, written discovery, okay, depositions, no, but that was based on what family law recommended. So, you know, I don't know what to do with discovery. So that's where I'm coming from. What are other people thinking on this one?
Well, I'd like to hear what Stephen Hamilton has to say as it pertains to any nexus with the family law group. Stephen?
Yeah, we haven't got there yet, have we, Julia? Because we haven't had a discussion since the default court appearance permitted was approved. Do you,
Is that what you were referencing, Julia? Overlap with family law vis-a-vis in-court representation?
Well, I think I felt very strongly after hearing from the judges and Justice Petro about, you know, wanting, they'd rather have at least somebody in court for a bench trial making a record. And I think Steve Fleshman asked them, I mean, better than them by themselves. And they said, yes, they're fine with them making the record. And there was just a real need for assistance in the purview of family law. And so that's where I'm sticking with, is that I was very moved by that conversation that included representation for bench trials and things of that nature. So I would be thinking about this in terms of how I felt for family law and that kind of in-person representation in court.
Okay, so you're speaking to the bench trial issue, not the other that Steve raised in terms of preparing substantive motions.
Correct. I think those kind of things we have to really deal with when we're dealing with each kind of subject matter endorsement or whatever we're going to call them. I mean, but I do not see them doing unilateral MSJs. But every area I am not real familiar with family law, so that's why I defer to others.
Okay, so and to follow up on that, and you mentioned some things, we heard from many professionals in this area who said that it's not better to have someone than not have someone. These are records that will potentially impact millions of people if they're done wrong. And so the odds and the risks of this group being included is far too high at this point. And especially when this is a hydra. And I think I brought up the point and have talked to people in between that when you say can do MSJs, can't do bench trials, there is a world of things in between there. When it says including this, it doesn't say excluding but not limited to. This is a hydra that is going to not be able that if you say that it's the Board of Trustees that has to decide this, that's a lot you're asking in terms of, and we don't know where this resolution is going to end up or look like. So
well, what were the versions on top of Steve Fleshman's? What were the first two, Linda?
These are the ones I drafted, one with exclusions and one with both inclusions and exclusions. I have a bias towards the exclusions only just because I'm thinking about how this is going to practically work. But in that version, I excluded the substantive motions. I excluded participating in trial setting. I tried to take this from our last meeting. And I excluded representing clients in trials. And that means by default, everything else is included.
Yeah, you're talking here about people who, and again, I heard in regulation, trying to put warnings into the retainer agreements that says you have other rights and abilities to get help. This is talking about impacting Rosenthal Act and other federal regulations that really they provide for attorney's fees. We can't amend them. You're not going to go into the Rosenthal Act. But this, again, it seems simple. It seems like something you want to help the little guy with, but it is going to potentially eviscerate absolutely important law on consumer protection. So while it seems good, this is not one that is really, especially if you have to go in and make this Swiss cheese. You know, I know everybody's trying to make this fit and work on a lot of different levels for a lot of different people, but look at the Swiss cheese we've created to try and make this fit into our paraprofessional program. This is not a fit. If we have to work this hard to twist all the way around to get this in, it's not right. It's not a good thing.
Well, can we leave it without?
I think I can better answer your question now too, Joy. Because this is restricted to, I don't think that rule is applying to the family law because that's going to be a separate provision. And we don't do summary judgment. We can't do a summary judgment or summary adjudication motion in family law. They took that away about 10 years ago.
So I like version 1 with the exclusions only. I think this works. I think consumer debt is one of the highest number of cases and default judgments and self-represented litigants. And so this is limited to individual debtors in limited jurisdiction consumer debt proceedings and has the exclusions that we cared about. I do think in terms of the in-court, and I'm sorry I missed that important meeting. You know, there was a middle ground, the Washington model. I don't know how people feel about it, but that's where the housing committee went, that paraprofessionals could attend in court, but couldn't advocate and could answer questions and could help support and answer, you know, whisper in ear. And I do think that might be very helpful in these kinds of consumer debt cases as well.
Jump in for a second on that. The whispering, just from my experience, and I've probably only had, I think I've had a couple of hundred consumer debt cases in limited collections. The whispering in the ear is not useful to the bench officer. All it does is take up time because it's, you know, I'm asking Amos a question. Amos turns to Stephen to ask the question. I'm sitting there the entire time. Stephen turns back to Amos. Amos then says it and Stephen goes, oh, you didn't get it quite right. And there's this it doesn't work. I mean, from my point of view, like doing the whisper at counsel table while you have a full courtroom and a judge sitting up there, you know, what's the point of that? You all can have the discussion amongst yourselves as far as responding to questions or not. My experience, just so you know, for what it's worth, and it was only in Alameda County, my experience with consumer debt was there were no motions other than, and I wanted to raise this because the one motion that I would see come up or that I wished someone would bring with more regularity was to set aside a default. Because a lot of times defaults are entered. And I know many times I had consumer debt cases, limited cases, that when I would then set the prove up hearing and require plaintiff's counsel in that event to come in and prove up their case with some frequency, when I would hold them to task, they actually couldn't prove appropriate proof of service. It was not properly served. And the function of getting a default, as you know, is a ministerial function in the clerk's office. And that goes through, and it can go through very easily. So really, from my point of view, from a consumer protection point of view, from a straight access to justice point of view, I wish there were more motions to set aside. And that's the motion that I see coming up in these cases. I don't remember a summary judgment motion or anything like that. I'm not saying it couldn't have happened, but talking about limited consumer debt cases, not the unlimited, where of course you do see those kinds of motions. In limited, I just don't remember seeing any of that. So anyway, that's just my 2 cents from firsthand experience in Alameda.
So can I respond then to Justice Petro? For what you've said then, I think version 2 is more along the lines of something specific that you would think that judges would find acceptable, that would be helpful to
Well,
you?
it's not really a matter of what the judges find acceptable in the sense that, the judges are going to do whatever they're told to do. If they're told paraprofessionals can do certain things or not, it's not our business to legislate and not our business, as I would always tell juries, it's not up to you to decide whether you like the law or not. I might rewrite this differently if I were writing it, not my role. And I think the judges are clear that's not their role. But
Okay.
my 2 cents though is what would be helpful to the debtors or purported debtors, because sometimes they're not really debtors, right? There's an issue there about whether the agreement is truly enforceable or whether the interest rate was appropriately calculated or various things. So from a consumer debtor protection point of view, from my seat that I used to have, yeah, I wish that they could get some help with default. I wish they could get some help with negotiations and with the prove up letters. So I do think that the number 2 is more along the lines of where I think you could most help people. I personally, and I'm not voting on this.
I understand.
I think it would be fine for them to be involved with the bench trial. I mean, again, it's very different in my experience, limited collections versus unlimited. But the limited collections, it's really the representative from the bank or whatever it is having to show up. Or under certain circumstances, and I don't recall the statute, what is often done is there is an ability to do the prove up hearing via declaration, so long as all the information is provided a certain amount ahead of time, and so long as the person executing the declaration is within a certain number of 100 of miles or 50 miles, I can't remember, within a certain distance from the courthouse such that they could be subpoenaed. So understand also, and I'm sorry if I'm preaching to the choir, but I don't know if anyone here has done much in the context of limited debt collection, but often what will happen, actually the proof is in the form of a declaration. And so it's someone going through that. These are not cases where you have a parade of witnesses. Now, maybe the debtor would want to get up and testify concerning, I never signed that. I had a couple of cases that I wound up dismissing because it really seemed to me like that person hadn't really signed that document. So anyway, if I were voting on it, I'd let them do the prove up hearings, referred to as bench trials here. That's just my personal view. But I also wanted to mention that often in the context of those bench trials, you're dealing actually with paper, not with a live witness.
Well, I like version 2 better than version 1. And the only thing I would say under the included activities in the first bullet, I would just say assist with motions for default or to set aside the default. I wouldn't say answer motions to set aside, because you're going to be the mover.
Isn't that the first bullet point, Julia, under included activities?
But it says answer motions to set aside default. It would be answer.
No, it should be assist with answer and motions to set aside default.
Okay, so why can't we just say assist with motions for default? Either it doesn't matter to me, but I agree that should be included, because I recall from that discussion that those kind of things, and I'm sorry, Justice Petro, I didn't mean to say that you were assisting in the proposing this, but I heard the need and how it could be helpful to the litigant, and that's what we're, I think, attempting to achieve here. So
we have several hands up. I just want to clarify. If something's not listed in version 1, it doesn't mean it's excluded. It means everything that's not listed is included. So I just want to clarify that. But I think Amos has his hand up, Steve and Carolyn. Do you want to go ahead, Amos?
Yeah, so that was one point I was going to make. The reason why I like version 1 better is because it is more inclusive. Certainly the things listed in version 2 are important, including helping with the answer and helping with motions to set aside default. So I 100% agree with the comments that those should be included. The concern I have with version 2 is it suggests those are the only things included, and there are other things that relate to what a paraprofessional would be doing if they're representing a debtor in limited jurisdiction cases. The other thing is, I don't know that this would include the prove up hearings because this is limited to representing debtors. So it really is for the in-court part that we're talking about the exclusion. Again, I like version 1, and the only issue I was raising is, I know it's not that helpful for, it would be more helpful for the court if there was full representation, but it still might be helpful to the court and certainly would be helpful to the client if the paraprofessional could be there at counsel table, help them, support them, and if the court has questions, answer them, even if they're limited to not advocating. So that's what I would suggest is version 1 with that clarification.
Well, we did kind of talk, Amos, with at the in-court representation that would be contemplated. So, you know, I'm at a loss of why we would do it different than what we voted on at the last full group meeting.
And what I'm suggesting, by the way, is consistent with, I think, what the housing group is proposing.
But housing excluded bench trials, correct?
Correct.
So I
Actually,
personally would like-
that's not. I have the resolution for housing, and it excluded jury trials, but not bench trials. It excluded jury trials and then also allowed a responsive representation, which is to sit at counsel table and provide guidance as well as respond to questions from the judge. That's the resolution that was projected during the meeting.
So I'm not sure we're agreeing or disagreeing. Maybe I'm just a little unclear, but I think housing voted or intended to vote to exclude trials either by jury or by bench, but allow paraprofessionals to be present in court and to respond to factual questions by the bench.
I watched part of the meeting and that was clearly the sense I got.
I just
Okay.
remembered that in the full group, when we talked about in-court representation, we left bench trials on as part of the resolution, not jury trials. And then we allowed it that each then substantive group could, for whatever reason, carve out bench trial or anything else that had been included in the main in-court representation vote.
I agree with you, Julia. We voted jury trials off the island and it's up to the individual subcommittees. My point is simply housing voted bench trials off. I think for the sake of consistency, we should sort of give them some deference. And again, when Erica asked that bench trials be included, it was my strong sense that she had family in mind, not consumer debt. I mean,
We're
that
not
was
gonna, just to be clear, we're not gonna speak for Erica on that because she's not
Yes.
able to be with us today. I'm not convinced. Certainly Monica Wiley was speaking in regards to family. That is, you know, her area of expertise where she has been for, I think, about the last 8 years. Judge Yu is not, is in a different position. And so I don't want to put words in her mouth on that. I'm not so sure that she was thinking about it limited to family. But I don't want to say either way.
I should have said that was how I interpreted Judge Yu's comments. Thank you.
Steve, do you still have your hand up? Because
Yeah,
you
I was gonna say, you know, I'm really torn on this because what Carolyn said makes a lot of sense and what Justice Petro says makes a lot of sense, particularly about the defaults. The only thing I wanted to add to this is we now know the market value for representation in these cases is $800. And how much help can a paraprofessional add if that's the amount that it costs to hire a lawyer? And I'm thinking about the discussion 45 minutes ago about utility shutoff. You know, I'm torn. Substantively, I think there's very little difference between any of the 3 resolutions. I can live with version 1. I can live with version 2. You know, I've got no problem dropping mine, but I think everything's encapsulated in version 1.
Then let's do it.
You want to do it, Julia?
Yeah, you're the
Oh,
motion
wait,
maker.
Carolyn has her hand up. Can we hear from Carolyn before we?
speak. I'm not sure it's going to change anybody's minds, but in regulation, I do understand that there's a discussion of it. Do you inform a paraprofessional's client that there are other rights and things available? And I think that discussion was happening with regard to the public services lawyers and pro bono lawyers. But I think in this area, again, consumer debt, there are significant opportunities when you want to talk to someone who's an expert. And I understand that some people think that, if, you know, that may be a limited subset of attorneys, but there should be some kind of, I'll suggest that in regulation at some point, if I can, you need to tell people that they'll have attorney's fees rights, all kinds of, you know, non-costing, you know, things that you can get into that they need to be fully informed. Written informed consent will be needed for somebody to understand that they may have a case that, again, will impact millions of Californians, if not themselves. So if you put a flyer in there, if you put a all blocks, you know, paragraph that people can read and understand that says, here are the statutes you're giving up that I can't help you with, but you can go see a lawyer or someone in public interest. You know, 5.4 says nonprofits are able to share with, now the Supreme Court just adopted that, nonprofits can assist. So
no, and
anyway.
I think that's a very, so just to chime in, I think that's a very, very important point. And I think it's difficult to balance because that is an extremely important point. And then I have my own experience of just, no one ever had any attorney. Like there were, you know, all these people who were coming in on these limited collections case. First of all, they often were not coming in. It was a stunning rate of default. So often there was no one, period. But then when I did have people show up, it was rare that there were any attorneys at all involved. And so I think, you know, it's part of the very hard work that our committee has, because everything that Caroline just said is accurate. And then there's the issue that, you know, what we're dealing with is people are not, the alternative is not, at least for the folks that I've seen, that they had counsel and now they're not going to have that attorney, but instead they're going to have a paraprofessional. I hope that some of these folks can get help who are not getting any help at all. But I think the piece about the regulation notice is super important.
Justice Petro, your best guess, what I've heard you say and what your colleague, former colleague in Alameda say is, as soon as a debtor shows up with representation, frequently the creditor walks away from the case. Do you think the same will be true if they show up with a paraprofessional?
I don't know. And I won't say that as soon as they show up with representation, the debtor will go away, because I saw it so infrequently. And let me also caveat this by saying different counties are different in their practices, okay? I was in a county and I had a personal practice of requiring pretty comprehensive prove-up hearings, right? Whether or not there was a defendant, you know, actually there. So even if someone was in default, it's always been my belief that the person holding the debt or the company owing the debt needs to actually prove it up and needs to actually show that they were served, you know, an appropriate proof of service and all the rest of it. I don't know that that's the case in all the counties. And I think depending on where you are, because of caseloads and other things, it can be harder or easier to enforce these, okay? So yes, I think that this is a large bulk business, and nothing against companies that hold consumer debt. I mean, that's a perfectly legitimate business and people owe perfectly legitimate debts that they need to pay off on. However, it is tend to be a bulk business with a lot of repetition. And so often, you know, perhaps as a business decision at a certain point, if there's enough pushback or information that needs to be gathered or, you know, whatever, there could be a decision made not to pursue it. So I'm not trying to imply that because someone dropped the case or entity dropped the case means that it was a BS case to begin with. I don't know. There could be perfectly valid decisions as to why to move forward or not. One might feel that if it's a small debt, it's not worth going through that. So I just want to be very clear. I don't want to give any implication that I'm saying it was wrongfully brought or, you know, incorrectly defended or all the rest of it. I'm just talking about the reality, which is there are a gazillion of these cases. They're often for the very limited amounts of money. People are regularly defaulted, you know, whether accurately or not. And when there's counsel involved or when there's the requirement to do additional work. Sometimes these matters go away, maybe because the evidence was not properly retained and so they can't do it. Maybe because a business decision was made. I can't say why, and I'm not trying to imply why, one way or the other.
Okay.
Julia,
Sure, yeah. Are we in a position for anyone to make a motion on any version of these resolutions or a modified version? If the only issue is the bench trial issue, we could have two different versions of either one or two, one that includes the bench trial, one that doesn't.
So I would like to make a motion, and just as I said, for version 1, I think includes it. So I'd like to make a motion for version 1.
I second it.
Any further discussion? Okay, Linda, do you want to take the roll?
Reynoldsson,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Hartston,
Yes.
Robinson. I see that you've joined us. Nicole,
My apologies for being late, guys. Yes.
Shining.
No, no.
Okay. The motion carries.
Leah, in your opinion, are we done?
Yes, but for, I just want to raise one thing. First I want to say congratulations. That was a lot that you all got through. There are a couple things that we need to do. The main one is the licensing subcommittee needs a recommendation regarding the specific educational and experiential requirements that would be associated with this recommendation, this set of resolutions. What I'm going to recommend, Linda and I just talked about this approach earlier today, is that we prepare something as staff, conferring with subject matter experts. And I do have to say there's beginning to be some reluctance on the part of subject matter experts to help us. But I think we can kind of do some work and come up with a proposal for you to consider. So there would only be one more meeting. We'd have something for you to consider in advance, and then it could be sent off to the licensing subcommittee. And that could happen sometime in May or even June. But other than that, I think you're done. Linda, correct me if I'm wrong. Amos, I see you have your hand up.
I think that's correct.
One issue that I think is teed up for this committee is whether or not contingency fees should be allowed in enforcement of judgment proceedings. The regulation subcommittee is trying to deal with fees. We have not reached agreement, so there's going to be a full working group discussion. But I think one area where the regulation subcommittee was inclined to allow contingency fees, may be subject to some sort of cap, is in the enforcement of judgment proceeding, where that might allow somebody to hire a paraprofessional without paying up front, may be subject to a limit. So I just wanted to tee that up.
So can I ask Amos, so when do you think the regulation committee will vote on that so that we have that in place when we consider it?
So the regulation subcommittee has not reached agreement on regulation of fees. That's one reason it's going to the full working group. But this is one area where we did reach agreement. We thought that contingency fees for enforcement of judgments subject to a cap may be appropriate. But again, I think this is the committee that's really dealing with that area. So if this committee has feelings about it, I think that would really control.
So,
Amos, in light of the votes we took today, my understanding is enforcement of judgments is limited to small claims judgments, which is $10,000. Speaking for myself, I have no problem with a reasonable contingency fee on that. I just want to make sure you agree we're only talking about small claims and nothing else.
Yeah, because we limited it to debtors otherwise, right? Enforcement of.
Carolyn, what did I say that was so off base?
You're on mute.
Yeah, well, I have been thinking about this night and day, and I do not have a conclusion on what this means. I think running into fee caps and talking about what people can charge and not charge, we'll see in May. In my own personal view, and not having tapped into the wisdom of the legal community, is that you start telling people what they can and cannot charge, and it's problematic.
So I'm just going to say I believe we're going to talk about the fee issues as a full working group on April 19th. Then we are also going to be voting on a set of proposed rules of professional conduct. You will, not we, at your June meeting. So there will be at least 2 full working group meetings dedicated to talking about rules, including rules around contingency fees. And I guess I don't know if, Amos, what you're suggesting is that this group would want to weigh in separately or on a parallel track to that process, but that just, I just wanted to put that out there, that we will be talking about it in April and June.
So it's not the April 19th meeting, is it? I thought there were going to be a special meeting in sometime in May.
That meeting is just on fee caps. I have not been including contingency fees in that discussion. In my mind, right? Because the rest of fees, there are a whole host of other fee related issues that are being folded into the RPC discussion.
Yeah, and I have a really hard time. I mean, knowing those rules are incredibly complex. They've been developed by the ABA, developed from the rules of, professional conduct. There's opinion letters, to wipe all that away and decide that we're going to define reasonable, we're going to define cap, we're going to define limitation. All of that not in the context of knowing anything else, not knowing who we're going to hear on the ethics issues, not having any kind of drafts or red lines or comments. I just don't know how you can say reasonable contingency fees over 8, 9, how many different areas of practice that we have? 8, 9, 10 areas of practice. Now some with trial, some without. I don't even know.
Just to be clear, what I'm not raising all those issues for this committee. I'm raising specifically whether contingency fees and enforcement of judgment proceedings should be allowed to have a contingency fee with a cap. That is what's being recommended by the regulation subcommittee, but this is the substantive committee in that area. So I think I should at least tee that up for you, for this committee to know about and potentially weigh in on. Stephen, can I ask you one question about,
Sure.
I think for this is also enforcement of judgments. I think earlier, not only were small claims court judgments the exception, but also I think it was wage hour judgments. Did that get lost?
It got allowed in the other committee, the employment and income maintenance, enforcement of Berman hearings in limited jurisdiction. My personal view about contingencies would be the same on that as I articulated for this committee.
Sorry, which was what?
Which was, I personally have no problem with a reasonable contingency fee given the amount involved. And to clarify, when I say reasonable contingency fee, in workers' comp and in MICRA, it's 15%. I think the standard PI case, it's up to 40%. I define reasonable as something in between those two numbers. That's simply my subjective belief, nothing else.
Okay, so I don't think there's anything for us to do on that today. I just wanted to highlight that that's probably going to come up on April 19th or later.
I had one small issue if we're done with that.
Yeah.
Could Leah or Linda or Justice Petra or whoever is appropriate convey to the health law subcommittee that health medical related debt is included in whatever we voted on today? I didn't want that to go unacknowledged.
Thank you for raising it because I forgot to, but that's exactly the conversation Linda and I had via email, that we think if you approve consumer debt, then the medical debt issue raised by health is encapsulated. So we'll make sure to do that.
Does anybody want to discuss that or have any votes on that?
I just briefly wanted to say that the only thing I know about that is that, like, for many insurance policies, and I believe Kaiser still to be in fact this way, is that just so we know that those kind of proceedings usually occur in arbitration and or mediation, so they're ADR, and so that would be a different kind of practice than is regularly discussed, just because of how those policies are written.
That's a really good point, Julia. That's never come up anywhere.
I am not certain we have jurisdiction to regulate who practices before AAA and JAMS and those ADR services. On the other hand, that could be the unlawful practice of law if not done right. My head hurts thinking about it, and I would be very hesitant to delve into that area without an opinion from Brady on that issue. And my guess is he doesn't want to give an off-the-cuff opinion.
But my question is, after that process is concluded and there is a debt that's owed, right? And when it gets to the point of collections, are you saying, Julie, the collections itself is handled through arbitration, not in Superior Court?
I haven't looked at the contract in a long time. But I have known a person who works for those entities as mediator / arbitrator. And so that's much of what they do, is they talk about issues that were listed in that memo, the co-pay, liability for co-pay, et cetera, et cetera. So I wanted to raise that because this is something that is outside of what we're normally contemplating for this paraprofessional. They may be venued in front of a different entity than a court, whether it be limited in jurisdiction or not. So that's just my only thought that I came to my mind when I saw this memo from the healthcare folks.
Linda, is that what you heard, you and Dana from the subject matter experts? I did not. I thought I had the distinct impression it was Superior Court debt collection.
I'm sorry, I was working on something else and wasn't completely tuned in.
It's just
It really didn't come up. It didn't come up at all. It never occurred to me. And I've never been in a Kaiser arbitration personally over bills and fees.
Oh, yeah, actually, now I know what you're talking about. Yes, it was only once the debt has been imposed and the collection of the medical debt, not during the time that it's in dispute.
Okay.
So, but if you've lost at Kaiser arbitration and they have a judgment against you, you're going to go back in and fight with Kaiser again.
You're missing a step, Carolyn. If you get a judgment, if you get an arbitration award, it is simply a enforceable contract. If you want to start collecting on it, you have to file a petition in Superior Court to confirm the arbitration award. I may be wrong, but I believe those have to be filed in unlimited jurisdiction under the CCP. I may be wrong about that. We haven't discussed that at all, to my knowledge. I don't think anything we voted on would include petitions to confirm or vacate arbitration awards. So to that extent, I suppose medical debt is not included, but it is not included to the same extent any other substantive type of debt is not included to the extent it involves arbitration clauses.
Or that it goes into an unlimited jurisdiction.
Yes.
You'll also have arbitrations. Again, I can't believe I missed this. You'll also have arbitrations in credit card debt. You'll also have arbitrations in all kinds of consumer debt. So you're going to lose the arbitration, and then the people that beat up on you in the arbitration are going to be people who are going to enforce the judgment. So
yes and no, Carolyn. If
go back at it again.
If there's a arbitration provision in your credit card agreement, yes, that's enforceable, but generally speaking, and Justice Petro, correct me if I'm wrong, but my understanding is if that bank sues in Superior Court to enforce that contract, that would be deemed a waiver of the right to arbitrate because they have selected a judicial forum. Could the debtor move to compel arbitration? Sure, I suppose. I've never even heard of that being done, but Justice Petro, how many motions to compel arbitration did you see in debt collection?
Oh, in debt collection? Oh,
Yeah.
I mean, I've had about 5 million motions to compel arbitration, but not in debt collection.
Yeah,
It could become a new thing.
No, don't need.
Okay,
Carolyn,
Amos,
take it back.
Great, where's my note?
Amos,
So I just want to agree with some of the comments. This isn't specific to health or medical debt, but arbitration agreements are all over the place in consumer contracts.
Right.
And I believe, and we can put Brady on the spot if we want to, but I do believe that a paraprofessional who attempts to represent a client in arbitration and give them legal advice and make legal arguments is practicing law, and it would be the unauthorized practice of law unless we authorize it. So it doesn't sound like it's something that we've contemplated or that we've considered, but it might be something we want to consider whether or not representing consumers in arbitration is allowed. And I'll also note that attorneys are obviously authorized to do that, but oftentimes attorneys don't touch those cases because they're too small and there's no class actions allowed. So oftentimes there'll be a class action lawyer interested in an issue or case, but when they find out there's an arbitration clause and the cases have to be done individually in arbitration, they don't really get full representation through those issues. The dollar amounts are often low.
Yeah, when Stephen first mentioned the question, I'm very confident in agreeing what Amos just said, that if we wanted to authorize that, we'd have to have a carve out from the unauthorized practice of law. What I'm not sure is if we did authorize it and AAA rules or JAMS rules or what have you didn't authorize paraprofessionals to appear or barred them from appearing, whether they could do that under the existing law or whether we could recommend they be required to. That I haven't thought of at all.
Steve,
I should have put my hand down, but just to respond to what Brady said, for the rollout pilot program, I'd really like to avoid arbitration.
Yeah, let's not talk about it. I just saw the issue.
Yeah,
Makes my head hurt.
Yeah, I know I'm not supposed to vote on anything, but yes, please, let's avoid arbitration.
Yes, I think we all agree.
The law on some of my partners specialize in arbitration appeals. The law on that is changing weekly. It is complicated. I'll just leave it at that.
Yep.
Well, that is the problem.
okay.
Some problems are just too much and yeah, our heads are all exploding. Thank you, Julia.
All right, so for now, what has been voted on with respect to consumer debt does include medical debt to the extent that it's showing up as consumer debt in the way reflected or envisioned by the resolution. So I think that's what will respond to the health committee. We'll respond to the health committee in that vein. And any subsequent meeting of this subcommittee would be to address a recommendation from staff about the licensing and experiential requirements, and to circle back on the contingency fee issue if it's not resolved in the April or June full working group meetings. Does that sound consistent with our discussion from everyone's perspective?
Yep.
All right, great work. I'm going to attempt to get out a draft memo tomorrow at the latest, even tonight, because I have already started it. And I'll look forward to getting your feedback on that. Okay.
Okay.
Thanks to everyone. Have a good evening.
Great, thank you.
Thank
You
you.
too.
Bye, everybody.
Bye.
Bye-bye.